Welcome to this week's OK at Work with myself, Sarah Sawyer, and my colleague, Russell Berger, both attorneys at Offit Kurman. And this week, we are talking about a recent Supreme Court decision that is impacting a lot of the work that we do in the employment space, other spaces as well, but something to touch on today is in the employment space, is the Chevron deference doctrine, which, without getting like super legal and turning this into like a Supreme Court legal podcast, the really basic way to set this up is that there's there's the Department of Labor, there's the EEOC, there's all of these administrative agencies that we talk about often on OK at Work and with our clients that have their views and policies and interpretations on the laws that they use, that they enforce, right? And in the past, there has been a certain way that's been handled when things go to court. And that is a deference to the agency's views on how these laws need to be interpreted. However, that is changing now with the Supreme Court decision. So what does that mean, Russell, for business owners who are looking to these agencies and their interpretations?
Yeah, a little less certainty is probably the starting point. I mean, because what was happening, right? Congress passes a law, and even when they read them detailed, there's oftentimes a lot of gray area, a lot of room for interpretation. How are we going to enforce this type of question? And these administrative agencies would answer those questions and provide guidance and regulations about how they're going to do it. And with this new Supreme Court decision, basically what they're saying is the court shouldn't be deferential or as deferential to administrative agency interpretations now, which means, like you're saying in the context of employment law, when the Department of Labor says, this is how we're interpreting this statute, or the EEOC says, well, this is what we think the discrimination law means, those aren't things that a court has to accept. And while they've never been something a court has to accept, they've always been something that, or at least since the Chevron decision, were things that courts were willing to go along with as long as the interpretations had a degree of reasonableness to them. But that's no longer the case. Now the court's just going to say what the law is. And that means that while the guidance is still a guidepost, and if you don't want the EEOC to come after you, you should probably still comply with the EEOC's guidance. It's going to be more, there's more room for defenses if you get into court, if you get into a dispute. There's space to push back that wasn't there before, which on the one hand is a good thing. But as I said a moment ago, there's also uncertainty as to where the lines are going to be drawn. And, you're going to have to figure out how to navigate that remaining space, which, at least in the handful of weeks it's been since that decision came down, we haven't seen employers rushing to say, oh, I'm going to take advantage of this, I'm going to drastically change things up. I think it's been largely business as usual, but I do think we'll see more pushback when there are, matters in court.
Yeah, and right now the precedent in the courts is based on that Chevron deference doctrine. So it's a little chicken and the egg situation going here. So it's like, the EEOC, for instance, will put together guidance based on what's going on in the courts and based on their interpretation of the law. And so it is just going to change the landscape, because now, we'll have some court decisions that maybe might differ from what we're seeing in the EEOC guidance or from prior court decisions that have been made under the doctrine. So it will, I think it's a slow moving, as is anything in the law. Nothing happens very quickly usually with these types of things. We'll see kind of a slow churn here where, there might be some differences between the way courts are interpreting things, are enforcing things and interpreting the laws, but it will take time for that to happen.
Yeah, well, and obviously this is not limited to employment by any stretch. I mean, this is all federal agencies, so it touches a whole lot of different things and a lot of different aspects of business. And I think that's why I started with uncertainty, is because we don't know exactly how it's going to play out. So like we have our guesses and we've shared some of our general thoughts as to what we think might happen. But the reality is we don't know exactly how this is going to play out. It is a change, and I agree it's probably going to take some time for that to settle in. So again, it's just something like a lot of things, business is going to pay attention to this, and you should, keep your ears to the ground on it. And as things evolve, as things change, as, you know, new interpretations of existing law come to bear, you adapt to them.
Yeah. And one thing I think just in closing to keep in mind too is that as this is developing, a lot of things don't end up in court that go through these agencies, right? There are a lot of, just like a lot of cases settle, a lot of things that having, matters having to deal with administrative agencies, they start with the agency. And so a lot of folks don't end up in court. They end up dealing with just the agencies, just the administrative bodies. And so they're still going to be using their interpretations at those stages of any types of proceedings or anything, at least definitely for now, until, something to do with the courts is informing their decisions. So not, as you mentioned, Russell, not anything that you got to run out and change immediately, but again, another thing to monitor, given that uncertainty. So,
Add it to the list.
so another thing to be on the watch for. Well, thanks, Russell. We'll see you next time.
Thanks, Sarah.